Hello, everyone, and welcome again once to Uncivil Law, or welcome once again. That would be the right way to phrase that. Welcome once again to Uncivil Law, and I hope you're having a great day. For today's case, we turn our attention once again to the wonderful world of Nick Rekieta and his wife. As I'm sure you more than recall, Nick Rekieta and his wife were found in possession of 26 grams and change of cocaine, plus other drugs, plus firearms in their home. And they've been accused of second-degree felony possession, and possession of a firearm by a person who's using a controlled substance, plus the fact the kids were there makes it child neglect by matter of law, that the children are in a place in which the drugs are present. Great. We've been following this case. Things have not been going super duper well for Nick Rekieta, but his wife does have one out that Nick at least left by the wayside, namely the issue of whether or not there's sufficiency of the warrant. Now, Nick all went up with, hey, they lied and they're super liars because watermark means the video is totes different. That was what he went with on the Frank's hearing idea. It didn't work. Kayla has decided to go with a much more reasonable approach by comparison of they just simply didn't have enough stuff. Your Honor, it's not that anyone lied. There just wasn't enough here. That search warrant shouldn't have been issued. That's a more reasonable approach. And we looked at Kayla's filings, and I said, okay, there might actually be at least some possibility here. There's some hope here, unlike the Frank's hearing where I laughed at it really, really hard. And then they appealed and I laughed at it even harder. With Kayla, I was like, okay, maybe. I mean, probably, almost certainly not, but at least you have an idea that kind of makes sense. As opposed to, but my watermarks, though. But my watermarks, though, was not the thing that was going to convince anybody. So anyways, Kayla has received a reply from the government on the issue. And so we're going to read the reply and see how the government feels about the issue. So we'll see. All right. The sole issue before the court, at least for the moment, is whether or not there's sufficient probable cause to support the search warrant. Based on the argument, the court should deny. Almost certainly will, but let's see what you got in terms of a reply. The U.S. and Minnesota constitutions provide that no warrant shall issue without showing of probable cause. In determining whether a warrant is supported by probable cause, the issuing judge's decision is not to be reviewed de novo, which is a pretty important issue, right? So, and I said this, I think, either in my first stream or my second stream. It was when the warrant got issued. And it was when the affidavit for the warrant got issued, I said it. I said, it's not even like whether or not I would do it, like as a reviewing judge. It's not even like whether or not I would issue the warrant. Like if I'm challenging the warrant, the issue isn't whether I as a judge would issue the warrant or not. That's not the right issue. The right issue is whether or not the judge effed up by issuing it, like basically no reasonable judge. So different judges obviously will disagree about exactly what probable cause looks like and whatnot. And would every judge have signed this warrant? Probably not. But that isn't the right issue. It isn't like, can I find a judge who would have wanted a bit more? Can I find a judge who would have liked this to be a little bit more detailed? That isn't the right issue. It's like, would any reasonable judge sign this? And if so, then that's the right standard. So we're not reviewing it de novo. We're not reviewing it from scratch. We're not reviewing it from base. We're not reviewing it without deference. We're reviewing it with deference. We're giving the judge their due. Judges get a lot of discretion. So is this in the Overton window, if you prefer, of acceptable decisions? That's the right way to look at this. Instead, great deference is afforded to the issuing judges of finding a probable cause. Yep. The review is confined to ensuring the issuing judge had a substantial basis for concluding probable cause existed. To determine whether the issuing judge had a substantial basis, we look to the totality of circumstances test. That language should also sound really familiar from my prior discussions. That should sound very, very familiar from my prior coverage of this thing, like the totality, the completeness of it, the whole thing combined rather than the individual components in its combined form. That's the right way to look at it. So this language should sound familiar. In determining whether it's probable cause to search, the issuing judge's task is simply to make a practical, common sense decision given whether, given all the circumstances set forth in the affidavit, there is a fair probability that the contraband or evidence of the crime will be found in the particular place. Yeah, practical, common sense, fair probability. It's not very much. It's a relatively low standard. In reviewing the sufficiency of the search warrant affidavit under the totality of the circumstances test, the courts must be careful not to review each component of the affidavit in isolation. And this is where I just stare back at you and be like, told you so. This is where I just kind of be like, see, that's what I said, yeah. A collection of pieces of information that would not be substantial alone can combine to create sufficient probable cause. The sum is greater than their parts. A warrant should not be invalidated by construing an affidavit in hyper-technical rather than common sense fashion. Again, it is more of its combined thing rather than looking to like every word and every dot and every thing. It's more of a impression than an exacting review. Wrongful Rage for $9.99 says, Kurt, there once was a law pope that did unlawful coke, and lo and behold, he tripped his prick on his toes, dirty 304. Allegedly. Thank you very much, Wrongful Rage, for your nice super chat. Doubtful or marginal cases are resolved in favor of upholding the warrant. So again, the question is sort of the Overton window. Are we anywhere in the bound of what a reasonable judge would do? So is it solid? Is it good? Is it okay? Is it marginal? Is it a little shaky? If the answer to any of those questions is yes, then the answer is the warrant should be sustained. Only if the answer is no, this makes no sense. I don't know what the judge was thinking. There's clearly not enough here. What are we even talking about? Are we going to overturn the warrant? Plus, once again, drugs. But drugs, though, also go, unfortunately, a long way in the Fourth Amendment analysis. The war on drugs has not necessarily been kind to the Fourth Amendment. So, but drugs, though, also is not a helpful factor when it comes to this motion, comes to Kayla's motion. Because it's like, the warrant was illegal, but the warrant was for drugs. So that doesn't help with trying to overturn the warrant. The affidavit must supply specific facts to establish a direct connection or nexus between the crime alleged and the place to be searched, particularly in the case involving the search of a residence. We have to have sufficient indicia that we can find the thing we're looking for in this place. That is the sort of the thing. However, direct observation of evidence of a crime at the place to be searched is not required. It is certainly not required. It's a nice bonus. It is a nice to have, but it's not required. A nexus may be inferred from the totality of circumstances, including the type of crime, nature of items sought, which then again is where the but drugs though factor comes into the equation, extent of the defense opportunity for concealment, and normal inferences as to where the defendant would usually keep the items. A finding of probable cause may rest upon evidence which is not legally competent in a criminal trial, which is to say, for example, hearsay. We allow hearsay in a search warrant. We even allow hearsay upon hearsay. So evidence, the evidentiary standard for trial is not the same as the evidentiary standard for probable cause. We will allow more suspect evidence in. We can note it's suspect, we can note it's low quality, but it's not barred. It's permissible. Police officers may rely on, thank you, Iron Rabbit, for being a member for 10 months. Police officers may rely on training and experience to draw inferences in affidavits. Like, for example, the police officer who said, I've been a drug recognition specialist and I know what being on drugs looked like, and this looks suspiciously like someone who's on drugs. Generally, in determining whether probable cause exists, both the district court and the reviewing court may consider only in the information for the search warrant. We do tend to look to the four corners of the document because it's what the judge signed off on. So is it in the search warrant or is it not in the search warrant? That's typically what we look for. The affidavit for the search warrant begins with a child maltreatment report that was taken by Deputy David Nestor relating to controlled substance use by defendant's husband. Once Detective Pomplin received the child maltreatment report, he began an investigation into whether or not there was criminal activity relating to controlled substances, which is fine. Investigations go where they go. So this initially started life as an investigation into whether or not there was child mistreatment. And along the way, the detective said, well, maybe I'm less interested in that particular issue, but I'm more interested in the issue of maybe there's drugs. And I'd like to investigate that now. Like, okay, you do you. The name of the reporter or the relationship was not included in the affidavit. However, the name of the reporter of child maltreatment may not be disclosed, although we do know what that is now. The report was the basis for the start of law enforcement's investigation. It was not the entirety of the investigation nor sole basis. Also, the name of the reporter is not particularly important because we're doing a search for drugs. So the person who made the initial report as to potential child neglect is less important because it doesn't really relate to whether or not there are drugs in the home. I mean, you can sort of make some ties, maybe, but it's not really the thing, right? I think the children are being mistreated, and I think there are drugs in the home are somewhat distinct issues. So the fact that the name of the reporter is a little bit distinct because the investigation kind of went in a distinct direction. Even if the court were to strike the information about child maltreatment report from the warrant application, there's still probable cause. So if you want to go so far as to say, okay, all this child maltreatment stuff is completely irrelevant, which I think is a perfectly reasonable conclusion. It's like, okay, all this child maltreatment stuff is completely irrelevant. This is a search for drugs, Your Honor. And so it shouldn't have any of this child maltreatment stuff. It's totally irrelevant to the issue. Be like, okay, so even if you got that far, what you do is you just sort of, you strike that information from the warrant. You just remove that. You remove that because what happened is you provided more things than you provided irrelevant things, but we're concerned about, is there enough relevant stuff? So it's like, okay, I'm going to strike this piece. I'll strike these pieces from the warrant affidavit. They're irrelevant. And given what's remaining, is there still enough there? And the answer being yes, then we move on with our lives. Detective Pomplin went on to review the social media of the defendant's husband, Nick Rekieta, but he might have watched a watermark video, don't you know? Which is totes different. The videos are available to the public. Detective Pomplin noted a dramatic change in Nick Rekieta's appearance from January 2024 to May 2024. He lost weight, appears tired, and overall strung out, which is common for users of controlled substances. There seems to be sufficient information from which a person could reasonably draw that conclusion. These videos were recorded in the home of the defendant. They sure were. Detective Pomplin also reviewed social media of Aaron Imholt. In his videos, Imholt talked about experimenting with cocaine and other controlled substances. There are no direct statements by Imholt that the defendant was using controlled substances. Detective Pomplin pointed out that Imholt insinuated use by the defendant but did not directly state that. In the application for the search warrant, Detective Pomplin notes there was a pre-existing relationship between defendant and Imholt. By referring to prior videos which they appeared together, or Imholt appeared from defendant's home. Detective Pomplin included that there may have recently been a falling out. There does seem to be some indicia that not all is necessarily well between the Rekietas and the Imholt. He also indicated that Aaron Imholt and April Imholt have separated. She has, and she's not Imholt anymore. So, yeah. Detective Pomplin informed the issuing magistrate that Imholt and defendant were no longer on good terms, which means that they knew that, so that's fine. Imholt also talked about a video in which defendant appeared to be under the influence of the controlled substances. Detective Pomplin did not rely on that statement alone. Detective Pomplin watched the video. So it's like, oh, there's a video in which he's acting like he's under drugs. Let me go watch the primary source material. Yeah, that sounds pretty reasonable. Detective Pomplin has been trained as a drug recognition expert, where he's received specialized training to identify the signs and symptoms when someone's under the influence. Based on a review of the video, Detective Pomplin stated defendant was showing signs of being under the influence of a controlled substance. While Detective Pomplin could not provide field sobriety testing, lol, he is able to recognize the physical signs of being under the influence of controlled substance. They are observed visually. They can be observed in person and through video. And while I will take note that there is some difference between in person and video, they're not one and the same. Anyone who's ever had a meeting like in person versus on Zoom knows they're not exactly the same. That being the case, however, although they're not exactly the same, the certain behaviors might be detectable even if they're on video. So while video and in person may not be one-to-one, if I've been trained as an expert on recognizing it in person and I watch a video of you for 4 hours, I might be able to reasonably draw some conclusions. Just saying. In determining whether there's probable cause to search, the issuing judge's task is simply to make a practical, common sense decision whether, given all circumstances set forth in the affidavit, there's a fair probability that contraband or evidence of crime will be found in the particular place. The application and affidavit do not have to prove beyond a reasonable doubt, because that would be really, really dumb. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of activity. The significant fact being not whether particular conduct is innocent or guilty, but the degree of suspicion that attaches to particular types of non-criminal acts. Thus, innocent or non-criminal activity can contribute to the totality of circumstances on finding a probable cause, which is very true, for better or worse, incidentally. And I can give you another example on this issue, by the way, when it comes to searches of cars, just so long as we're trying to learn something of legal value. So you might have a whole bunch of conduct that is legal, but together makes for legally suspicious behavior, which is controversial in some circles, but a lot of courts have upheld it. And one circumstance in which it's been upheld has been relating to vehicle searches. So, for example, this car has out-of-state plates. It's traveling this particular road. This is a known drug corridor. It was 3 a.m. That's the time that drug people use the roads, and that kind of thing. So a combination. So this could be a perfectly innocent thing, but there have definitely been courts that have upheld searches of cars because, well, you were traveling at 3 a.m. on a drug corridor, and you have out-of-state plates and other suspicious things. So you can use legal behavior that seems to, in combination with other things, seem like something is suspect. You could be doing something that would be legal for illegal reasons, for example. So, to make a very trivial example of another trivial example. Let's suppose it appears I'm breaking into a house. Let's suppose it appears that I am, I've got my crowbar and, I'm at the front door of a house and I'm prying the door open and a cop sees me. Okay. Am I breaking the law? Well, here's something that would be really helpful to know. Whose house is it? If it's my house, it's legal. If it's not my house, less so. But of course, the cop may not necessarily know that. So the cop, seeing me with my crowbar on my front door, trying to break the door open, he might reasonably think that this is a crime, even though it is legal behavior. So that's another trivial example. Let's see, where were we? Police officers may rely on training and experience to draw inferences in affidavits. In this case, Detective Pomplin relied on his specialized training as a former drug recognition effort and his prior 15 years of experience. Based on that training and experience, he was able to articulate the signs of controlled substance use that he observed in Nick Rekieta's video. Even if there was an innocent explanation for some of those indicators, like, for example, I'm trying to break into my own home, or it was drywall on his nose, that does not negate Detective Pomplin's training and experience and deduction he's able to make based on these indicators. Yeah, ultimately, we're not trying to determine what's true in reality. We're trying to get to probable cause. We're trying to determine whether or not there's indicia of crime, whether there's a substantial chance of crime, not whether or not it is a crime. So forth and so on. His subsequent investigation and his personal observations of Nick Rekieta in his videos corroborate the information provided to Deputy Nestor about ongoing controlled substance use in the home. The totality of the facts in the search warrant application established the direct connection between the controlled substance and the defense home. Even if this were a marginal or doubtful case, the Supreme Court has mandated the resolution of these cases should be largely determined by preference to accord the warrant. The U.S. Supreme Court has said warrants basically are presumed valid in so many words. Additionally, courts are to offer great deference to the issuing magistrate's determination of probable cause. Again, we give the judge the ability to judge. With this in mind, the search warrant application taken as a whole demonstrates the issuing magistrate had a substantial basis for concluding that probable cause existed to support the search warrant. And thus the motion should be denied in its entirety. Well, I think that's basically correct. I had previously given Kayla Rekieta's motion 5 or maybe 10% chance of likelihood, but even at the time, that was too high of a percentage. So I think her odds of success are like 1%. Her odds of success are like 1%. So it's not quite I'm going to laugh in your face, but it's also not you're going to win. The problem, as always, is that probable cause standard is so low. And but drugs, though, goes a long way. No one's going to say, but drugs, though. No one's actually going to write that. But the reality is, but drugs, though. But drugs, though, goes a long way. And so, yeah, I think that her odds are basically 1%. The standard for probable cause is really low, something like 1 or 2 out of 10. 10 or 20% is something like that, is in terms of our confidence level. If preponderance of the evidence is 51%, and if beyond a reasonable doubt is something like 95 to 99%, then probable cause is something like 10 or 20%. It's not very much. And you can use less quality evidence. And of course, they did ultimately find drugs, which makes things problematic for the idea of suppressing it. So I think Kayla's odds of success are basically 1%. Because not only do you have to show that the warrant shouldn't have been issued, which I still think it was, not only do you have to show that the warrant shouldn't have been issued, but you have to show that the judge made essentially a categorical mistake in issuing it. So not only would the reviewing judge, not do this, but they think the underlying judge was basically off their rocker that day. So yeah, I think Kayla's odds of success are roughly 1%. So that is, fundamentally where it's at. So the next thing that's supposed to happen is Nick Rekieta is supposed to have a plea settlement conference relatively soon, I believe, to be honest. I want to know if I can find out the exact date. Let's see. Probably, can I find out the exact date? I want to say it's on the 17th, but I don't know for sure. Give me 1 second. No cases match my citation. That's great. Thanks. Let's see if I can find the exact name. Notice of hearing. December 17th. Yay, my memory was correct. So the next thing that's supposed to happen is there's a settlement conference on December 17th at 3:45 p.m., at which time Nick Rekieta will, presumably have to either shit or get off the pot. He's already had one deferral on this issue. And presumably he's going to be forced to either be like, okay, we're going to trial, or I'm going to enter a plea. And the indicia seem to suggest that he's going to enter a plea. And I'll make a bet as to what that plea is, so we can see how good my predictive powers are going to be. I don't know. The state's really pissed. The state's probably pretty pissed. So I might be being too generous, but I'm gonna make a prediction. Let's see how close I am. My prediction is that the plea is to possession in the 4th degree. He's right on the line of 3rd degree anyway, because 25 grams is the threshold for 3rd degree. And he has like 26 and change. That includes packaging. So my prediction is that they plea him down to 4th degree, 2 years probation, and probably dismissal of at least one of the misdemeanors, maybe both. That's my bet. So we'll see how close I am at the end of the day. But of course, a lot depends on how pissed the state is about having to go through all this. But they still have to. The thing is, the reason the reason the state would offer a deal is, as I've said before, one is they're largesse. They don't really want to beat up on first-time drug offenders with no criminal record. They're a blue jurisdiction, blue state, and they want to just be merciful. So mercy is one factor, and the other factor is time, expense, and certainty. They still have to prep for the trial. They still have to put the witnesses on. They still actually have to conduct the trial. That is energy, money, time, and other things that could be used for more productive exercises. So in the interest of efficiency, they would be offering some kind of deal. But I think that there's going to be a felony. I think he's going to walk away with a felony, and I don't think there's going to be a conditional discharge. I think if there was ever a chance for conditional discharge, that chance has expired. If there was ever a chance of walking away with this thing with a conditional discharge, it was long ago. And I don't think the state's in a particularly glorious mood. So my prediction is 4th degree with one or both of the misdemeanors being dismissed. 2 years probation. We'll see. He won't be disbarred for this. He won't be disbarred for this. No. However, if there's any truth to the idea that Nick Rekieta looked at Aaron's attorney-client communications, because this has been one of the things that has been suggested, which I don't know whether or not there's truth to that, but it's been suggested as a possibility that Nick has been looking at emails in a way that might be a violation of potential computer trespass law. If those emails included attorney-client communication between Aaron and his lawyer, Nick Rekieta will get disbarred so hard they're going to make his head spin. So if that turns out to be true, he's going down super duper hard. Not to mention, of course, the super felonies for the computer trespass. Take your pick between which of these things is it going to wind up being, because we don't know enough to know for sure. So at this point is, which of these things does it wind up being if it winds up being true? Is it computer trespass? Is it computer fraud? Is it a violation of the Federal Computer Fraud and Abuse Act? Which of these things is it? We're not sure yet, but there's so many possibilities and none of them are fun. So if that turns out to be true, then Nick Rekieta gets disbarred, and he goes to jail for 5 years if he's lucky. So yeah, we'll see. What happened with the computers? It has been suggested that Nick Rekieta has accessed computer accounts that are not his own. It has been suggested that Nick Rekieta has accessed accounts that are not necessarily his own accounts. And therefore, he has accessed someone else's accounts, potentially without permission. And that raises all kinds of problematic issues. He'll blame it on April. Nice. Identity theft? It might be technically identity theft. I'd have to double check my identity theft law. I mean, he wasn't trying to like overtly impersonate anybody. He wasn't like going out and saying like, I am this person, but it could technically be identity theft because sometimes if you use like someone else's credit card, it can be considered identity theft. And I'd have to like double check the finer points of identity theft law, but at least you have an idea. So if you go to a store and you use someone else's credit card, and they don't know about it, obviously, if you have permission, none of this applies. But if you use someone else's credit card and you don't have permission, not only are you potentially guilty of the fraud from, using someone else's credit card, you might be guilty of identity theft, and you'd have to double check your statutes on that thing, but it's possible. So is like the mere fact that he accessed the accounts identity theft? It might be. That's where we have to start, opening the books and checking the finer points of exactly how the statute is written. But you have the right idea. Yeah, fraud, identity theft, maybe. Wire fraud, probably not wire fraud. Computer fraud is better. Computer fraud is better than wire fraud, although the feds do love their wire fraud, so you got that going on. But computer fraud is better. Law and Crime really wants to see this go to trial. I kind of want to see it to go to trial. I want to see this to go to trial, man. I am coming up there. And I tell you what, man, if it is a Thursday, we're going to Stoney's. We're all going to Stoney's in Rockville, Maryland for $2 Thirsty Thursday, $2 cans for Thirsty Thursday. And I, your friendly uncivil, will buy the community collectively 100 cans because I'm just that nice. So if this goes to trial and it's a Thursday, we're all going to Stoney's, and the first 100 of you get a free can courtesy of your friendly uncivil. It's going to be fun. Wrongful Rage for $4.99 says, which of the law cardinals will elect a new law book? Am I a cardinal? Is that what I am? Am I a law cardinal? No, dear. Preferably without one using dope, allegedly or not. Hope the title fails off, of course. Yeah, I didn't know. I didn't ever contemplate before this moment. If Nick is the law pope, who are the law cardinals? Am I a law cardinal? If so, what am I a law cardinal of? Am I the law cardinal of Texas? What am I? This is an existential question I didn't know I had. $7 days to go to find the 17th. We should find out what he's doing with the deal. Yeah. Although he probably won't enter a plea on that day. He probably won't enter a plea on the 17th, which is just as well for me. Because if they don't enter a plea on that day, then that means that they're going to announce like what day he's going to formally enter the plea. They'll make the agreement, but he won't formally enter the plea. And if there's a break, if he doesn't enter the plea on the 17th, that means I get to contact the court and ask for permission to stream it, so that we can all watch Nick Rekieta say, "I did it, I did it, I did the thing." Biggest stream ever with that one? Could well be. It would definitely be a stream. It would definitely be a stream. Plus, people would almost certainly, photobomb. I don't know what would be the correct expression in this. Zoom bomb, I guess. They would Zoom bomb the court and say stupid and retarded things, because we've already had that with Nick's case a couple times. People Zoom bombing the court and saying all kinds of stupid shit because I don't know, reasons. And I just put my head in my hands and be like, please make it stop. Thank you, KJ, for becoming an uncivilian. Yeah, I'm sure that they are close to an agreement. Yeah. My bet's on fourth degree. My bet's on fourth degree with one or both misdemeanors being dismissed. 2 years probation. Maybe 23 months. It probably won't be exactly 2 years, because that's how they do these things, right? So before someone comes back someday and be like, oh, it's only 22 months, it wasn't 2 years. Okay, I'm rounding to 2 years, because usually it's like, it's not exactly. Usually it's just, maybe it's 21 months or 22 months. It's like, okay, it's close enough, man. It's close enough. I'm rounding it. Yeah, Kiwi farmers, probably the Kiwi farmers, some of them at least. It's like, dude, but it is a court proceeding. So, I mean, it's very disrespectful to the court. It's also very disrespectful. It's just incredibly disrespectful to the court. And so I don't approve of it on any level. It's like, you are literally basically standing up in open court and making a fool of yourself. Personally, I hope they find those people and they throw them in contempt for being disruptive assholes. I mean, that probably won't happen, but that would be nice, because it's contemptible. Would he have to stop doing drugs as part of the agreement? Yes. Yeah. He won't be allowed to do drugs or probably even drink for the next 2 years, which I'm sure will be super sad for him. No drugs, no alcohol for 2 years. Yeah, it's going to be rough. Thank you, Reed Scar, for being a member for 12 months. I do appreciate that. And before the judge issues federal warrants for contempt. Well, the judge can't issue a federal warrant because the judge is the state judge, but you would need a federal judge to issue a federal warrant. But yeah, that's unlikely. The feds tend to be very selective, and they tend to be very assured. There's a reason that the feds have like a 99% win rate once you factor in pleas. The feds win 99% of the time, a little bit more than that, to be honest. The feds don't fuck around. So like this, the feds don't bring marginal cases. The feds tend to bring cases in which they're sure. So if you have the feds up your ass, you have real problems, my friend. You have real problems, my friend. Medic Mark 22 for 10 Canadian dollars says, I really hope Nick goes to jail. He almost certainly will not go to jail. It's exceptionally unlikely that he'll go to jail. Even if he was convicted of everything on the table, he almost certainly wouldn't go to jail. He's a first-time offender. The recommended sentence is 4 years probation. So he was never looking at jail time. And there's really nothing here that would suggest jail time. So there's nothing that about this case that would suggest for a more aggressive posture. So I think it's exceptionally unlikely that he would go to jail. Horrible for this, for the drug thing, he'll go to jail. He may wind up going to jail for other exciting things, depending on how those investigations develop. But yeah, horrible to say, but he may get the help he needs to quit drugs. I would write him, prison isn't easy. I really hope the best for him and his family. That's fair. I mean, I hope in the end that he'll be okay. Yeah. Ethan Ralph getting a warrant was so odd to me. For what he did, and they issued a nationwide warrant. That seemed so. Yeah, I didn't think it was fair. I mean, Ethan Ralph may not necessarily be the greatest person in the world, but I still thought a nationwide warrant for this. I mean, it's like for a contempt. It's like it seemed deeply problematic. It also seemed like there might be some improper First Amendment retaliation or First Amendment issues in there, because it seemed like they were going after Ethan Ralph, not just because of what he did, but because of specifically like what he was saying. So it seemed like there was some unfair targeting to Ethan Ralph, based on my very limited. But my understanding is they resolved the case. So I believe that case has been resolved. So it's moot now, but it struck, once I looked into it, it looked kind of odd to me. Yeah, he said on stream he knew he couldn't stream and he was going to do it anyway because F the court. Yeah, I understand that. I get it. But still, a nationwide warrant, go get him no matter where he is because of that. It seemed a lot. It seemed a lot to me. I didn't think that was really appropriate. There's been some proceedings in the KR case. Yeah, I know. We were just reading it now. You think there's been proceedings beyond that? Well, that's why we did the stream. Is because of the KR case. The title of the stream is about his wife. You think there's been proceedings beyond that, like in the last 5 seconds? Oh, in the Karen Reed case. I'm sorry, different KR. Kayla Rekieta versus Karen Reed. Sorry, different KR. Yes, you're right. In Karen Reed, they have delayed the trial, which, okay, to a date that has not yet been established. It may seem like a lot, but I've seen nationwide warrants for same stuff from other states just for traffic stuff. That's a lot too. Unless it's like, the most reckless driving and evasion ever. A nationwide warrant seems a bit excessive to me. I don't know anything about Gino with respect to charges with respect to a felony charge. I don't know anything about a charge against Gino. This is the first I'm hearing about a charge against Gino. So I don't know anything about that. If Gino has a felony warrant against him, that's the first I'm hearing about it, and they haven't issued a nationwide warrant for it. That's the first I'm hearing of it. Would he have to stop doing drugs? Yeah, they'll drug test him. Yeah. Thank you very much, Eagles. I do appreciate that. Saying keep up the good work. That's very nice. What are my opinions on Karen Reed? I think Karen Reed is innocent. I think the case against her is bullshit. I think that Trooper Paul and Trooper Proctor kind of proved it didn't happen. I think Karen Reed is innocent. I think the case should be dismissed for lack of evidence. I think that the case going forward is an abomination. What do I think the odds of divorce are? Impossible for me to say. I don't know them well enough for me to be able to answer that question. I imagine that this is putting a lot of strain on their marriage, but it's impossible. But they have 5 children together, so you know. Plus, I'm a sucker for romance. I'm always hopeful that it'll work out in the end. I'm the eternal optimist when it comes to relationships. I don't really like divorce, you know. I always hope that it'll work out in the end. So I'm a sucker for a happy resolution. No, you shouldn't wear a Canton brainworm shirt and wear it to trial. No, that's not a good idea. Is there any way the feds can step in more to dismiss the case? No. Separate sovereigns, the feds have no power to force the Commonwealth to dismiss the Karen Reed case. They should, but they can't make them. So no. All right, I'm going to go ahead and sign off. Seems like we've reached the end of this chat, but we had a good chat, didn't we, together? I had a good chat with you. You had a good chat with me. We had fun. Fun was had by all. And I'm glad. Why do I think he's stupid for not taking the plea deal? Oh. Well, those comments were speculative. Like, because we don't know what's going on. But if Nick had shown more contrition at the start, right? Because, like, it seems like the evidence against him is really, really high. Plus, he definitely did it. So, because it's drugs and because it's a first-time offense, my thinking was that, if he had said, I'm sorry, and sought contrition, if he had had a more conciliatory attitude at the start, my thought was he was dumb for not seeking a plea because there was at least some possibility at the start for some sort of diversion program or some sort of other conditional discharge or some sort of other resolution that would have left him with no record or no record after some period of time or something like that. So my thought in saying that he was dumb for not seeking a plea was, well, this is a first-time offense. He has no other criminal history. I know he has got some traffic stuff, but that might be not criminal. Because Texas has this thing too, which I didn't even know it was a thing until I moved to Texas. But they have non-criminal misdemeanors, which sounds bizarre to me, I know, but that's just, yeah. Because some states deal with traffic stuff as a civil infraction, and some states deal with traffic stuff as a non-criminal crime? Question mark. Anyways, so like, yeah, he seems to like not have a criminal record, or at least one that's not worthy of mention. And so, you know, okay, it's personal possession. He didn't like act a fool, you know, in terms of the search itself. You know, he didn't like Tony Montana this and be like, say hello to my little friend. You know, he didn't do that. He wasn't breaching the peace. He didn't, you know, he isn't accused of distributing, and there's no indicia of distributing. So, you know, it's just a simple run-of-the-mill personal possession case of an otherwise law-abiding adult who has read a reasonably lawful life. And so my thought was he was dumb for not accepting the plea deal because there was some chance at bringing this down to a misdemeanor, a conditional discharge, a diversion program, or some other resolution that might have not left him with a felony on his record forever. So my reason for saying he was dumb and not seeking a plea is because, like, well, it seems like they've got you cold. They found the drugs in the home, Nick. It's like it's your drugs, Nick. So, you know, so unless you're trying to say, no, it really is someone else's drugs, you know, I was framed, which, you know, he hasn't been saying that, then seeking a plea was the best option. You'd be like, you know, I'm really sorry. I've left a good life. You know, please show mercy on me. You know, there might have been some opportunity at the beginning for a misdemeanor, for a conditional discharge, for a diversion program. And then Nick, by, you know, doing all the things that he's been doing, has made those things erode. Now, maybe it was the case that was never an option. Maybe it was the case that was never an option. But it would have been helpful to try to pursue it. It would have been helpful to try to be like, you know, to try to find that path. I think there was a realistic possibility. You know, the state probably wasn't going to go to the wall for a first-time offender for simple possession. It happens every day. Drugs are every day. The courts are flooded with drug cases. You know, if the state, if you can come up with a nice, easy resolution and just take this away from this, you know, make everyone happy, then that's, you know, that would be probably a good thing to do. So he was kind of dumb because he didn't really pursue that option, and instead went with, I'm calling the state and the cops a liar. They're a bunch of liars. Oh, okay. That's definitely the way to win friends and influence people. They're liars against me. Oh, that'll definitely ingratiate yourself with the government. That's the kind of thing the prosecutor loves to hear. That's the kind of thing that's really just going to make the prosecutor be like, boy, oh boy, I'm so glad I'm going to go work with this guy. He's calling me and the cops a bunch of liars. Boy, oh boy, am I ready to make a deal. So all those reasons would be the reasons I thought that he perhaps handled his defense less than optimally. And now he's probably looking at a resolution of a 4th degree with 2 years probation and his continuing supervision of what Nick Rekieta would call the fun police. Because he's not allowed to have fun anymore, because he's not allowed to drink and do drugs. How sad. In any event, I've been on Civil Law, and until next time, I hope you're well. Have a great day for now, and goodbye.